why you didn't search the house. You learn about Frito Bang, supposedly takes him somewhere. Why in the heck don't you search his house? Even if it's 4 months later, 5 months later, 10 months later, and use that fancy spray. Not the one that causes you to get sick, but the new spray. And look for it. What kind of investigation is this when we're talking about putting a young kid on death row or life without parole? Or any investigation? This is no game, folks. We're playing for all the marbles. That's why they said that Miramar Police Department lacks the training. They did absolutely nothing once they got that surveillance tape. Blinders on them. We're not going to look to the left. We're not going to look to the right. We're just going to direct everything to this young man.
All right, we are going to hit the pause button. I want to welcome my guests in the studio with me, family law and trial attorney Jenny Brown and law enforcement litigation expert Sonny Slaughter in Washington, D.C. Thank you, ladies, both for being with us today. Let me start with you, Jenny, and tell me what you think. We know that clearly the defense is trying to say, let me give you reasons for these things. So, for instance, the state said there's no reason for the Jeep to have stopped on the side of the road. I say to you, yes, we've told you he needed a bathroom break, just like anybody would. You raised your hand on the jury. How do you think his closing is going, Jenny?
What I really like about him is he's making it more simple for this jury. When I was listening to the prosecution, it was hard for me to follow as an attorney. So thinking about it from the jury's perspective, it had to be hard for them to follow. And as a reminder, he needs one jury who thinks that there's reasonable doubt. And that's what he's trying to plant that seed, is there could be 100 reasons why they stopped. And so I think overall he's doing a pretty good job.
And I agree with you. In watching the closing argument by the state, I too felt like it was a little bit of throwing different things at the wall, but I was having a hard time maybe connecting those things. But Sonny, tell us your thoughts about the closing argument right now by the defense.
Judge, thank you so much for having me with you. I agree with both of you. I think whenever we have being on a jury is complicated enough, and then when they're not clear and concise and consistency, I think it just convolutes everything that they're hearing. And as my co-guest said, they only need one juror to say, I'm not getting all of this. It doesn't make sense, and we really have to simplify things for the public. So I think the defense is doing a good job.
Let me ask you, because this is what stood out to me so far in the closing argument. Where are the weapons? Should it concern you? Yes, says defense in closing. Should it show you a lack of evidence? Yes. Sonny, let me start with you first this time. I think that in and of itself theoretically might give at least one juror pause to say, wait a minute, that's reasonable doubt.
Yeah, I absolutely agree. You really have to think about if he was the shooter and allegedly, then what happened to the guns? Where are they? Why didn't law enforcement find them? Where could they have been placed? Who else was involved? And as the defense attorney said, did they have blinders on? Did they only stop here because if they searched, if they looked in the area, we're coming up short somewhere. So I think it's reasonable doubt. There's enough reasonable doubt just on the gun evidence alone.
All right, Jenny.
Or lack thereof.
A lack thereof. Excellent point. And that's what defense is certainly arguing. Tell me in terms of trial skills. We know we've talked a little bit about the closing by the state, which we showed earlier today here on Court TV, and now we're watching the defense. Both of them are fairly long. I mean, they do go through a lot of the evidence, a lot of their argument. Any thoughts about any of that from your perspective as a trial lawyer?
I think that the charisma is huge for the jury, right? And the defense attorney is connecting with the jury. But what he's also done is he's mentioned to the jury numerous times what the consequences of them convicting him are, and to really know how heavy of a burden that they have on them at this point, because the choices are life in prison or death.
And I'm glad you mentioned that, because that's something you and I just talked about briefly while we were watching, and that is, you're right, it's 2 counts of first-degree murder with a deadly weapon, and there are 2 victims. We know there was 21-year-old Anthony Williams and 19-year-old Christopher Thomas. To your point, the sentencing is heavy, and this jury has to decide guilty or not guilty. All right, ladies, stay tuned. We have to squeeze in a break, but when we come back, we're going to get you more into the defense's closing argument. You won't miss any of it. Stay tuned here on Court TV Live.
Tonight on Closing Arguments, an arrest has finally been made in the Long Island serial killings. Our experts break down the investigation and what's next for the defendant.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
One day she literally just disappeared.
Bo claimed Ryan Duke did it. Ryan Duke claimed Bo did it. Who do you believe?
Accomplice to Murder with Vinnie Politan. All new episode, Sunday night, 8/7 Central.
With me to help discuss closing arguments, family law and trial attorney Jenny Brown from Marietta, Georgia, and law enforcement and litigation expert Sonny Slaughter from Washington, D.C. All right, Jenny, let me start with you. I really liked one of the things he concluded with, ladies, and that was, if you waver and vacillate, that's what reasonable doubt is all about. What a great way to think about it.
I agree. He's saying if you have one iota of doubt, that is reasonable doubt, and you should not convict. And he even said, if you think he's involved, that's not enough. And I think that's really important for this jury to understand, is he might be involved, and you might even think he's involved, but you have to confidently know he pre-planned this, and he either shot them or was immediately with the person who did.
And I love the way you just summed it up, because it is true. If you think maybe he did it, that's very different than he did it beyond a reasonable doubt based on the evidence presented. Let me mention, Sonny, before I get your thoughts, that we are watching closing arguments from a little bit earlier. We now know the jury, and everyone can look at their clock on their screen. The jury's actually been deliberating for 12 minutes. So I just want everyone to be aware that the jury is out deliberating. But while that's going on, Sonny, a perfect time to, first of all, get your thoughts again, now that he concluded his closing argument, and he did make a lot of arguments about life or death, life or death, life or death. That's what you are, this man is facing based on your decision. How compelling do you think he was?
I think it was really compelling, because sometimes when I think when we're looking at these trials and we're not a part of the jury, we don't understand. I mean, we're here and we understand how we're feeling, but I think the jury has to understand how important this case really is. I believe they've been paying attention. Hopefully they've been paying attention. But when you're deciding somebody's life in prison or death sentence, that is a heavy burden to carry, and they really need to be focused. I think he did a good job getting them zeroed in at the very end on whether not a little bit, but all the way in. So I think he did great. Yeah. We'll see.
He sure was passionate. I'll tell you, we talked about it. The thing that really stood out to me was when he reminded the jury the state had a sworn statement from a witness, and it really was conflicting to the state's case, because it talked about Melly got into the car when he woke up. So it was really evidence that didn't help the state, I would argue. And Jenny, you and I both noted that, wow, the defense said we had to call that witness, not the state. I was taught in trial skills in law school, you cannot ignore a bad fact. You have to put it out there in front of the jury.
Right, and in fact, you want to attack those bad facts, right? You want to lay it out there and present it why it doesn't matter to your case and why this witness could not be trusted. But instead, now the defense gets to hone in on that and say, look, I told you they had blinders. I told you they weren't looking at anything else. So much so that they had somebody come in and give a sworn statement that they didn't even want to show you. We're not the ones lying to you. The state is. And that's where he's really trying to lay this foundation of mistrust.
And I think it's a huge misstep by the prosecution. Sonny, weigh in. Do you think this is something that jury might rely on to acquit this defendant?
Absolutely, because that one fact causes you to question, well, if they didn't bring this in, why not? What else didn't they do? What other information did they have that we don't know about? And if it was strong, as my co-guest said, bring it out so you can argue in it. Argue the case, argue the matter, but if letting the defense do it, that is enough reasonable doubt, in my opinion, to say they don't have a strong case.
Yeah, I think it was a misstep, but we'll see what the jury does. Jenny, do you think that the defense included any arguments that really might have resonated with each individual juror personally so that they could feel themselves being put in the situation, even though that's the golden rule? You can't say that. You can't say, imagine if this was your son who was killed. You can't do that. But did he speak to each juror individually, in your opinion?
Well, let's remember, he only has to speak to one, but I think he did. I think that he tried to lay that foundation of fear of what happens if you were in the wrong place at the wrong time and then something catastrophic happened and then they had blinders and they only focused on you. We're talking about a child. He kept going back to his age and how young he is and the gravity of the decision that they're having to make. So I think he probably did get to at least one of the jurors.
All right, Sonny, let me get your last thoughts about the defense's closing argument today.
I think the defense really tied the knot on the missing components and information from the prosecution, and that the state's case was not as strong as they thought it was. There were a lot of holes. It was not clear, concise, and consistent. And I think he went through every detail and provided, closed the gap, I would say, on everything that the state missed. So I think he did a good job. Let's see what happens, because this is a very serious case.
Yeah, I would agree. I think this is a case that really he might get acquitted. Now, I also think, though, my opinion is that the state did put out everything they had. I didn't feel like the state didn't do a good job giving the jury everything they knew and had. I just don't know that it was cohesive or was necessarily enough to convince all of the jurors to convict.
And what they had was complicated.
Yes, I agree with you. And if you don't lay it out in an easy way to digest, you're right, that can cause issues when it gets back to the jury. So just a reminder for all of you on your screen, we will have the jury verdict clock. 17 minutes is how long they've been deliberating in Florida, and we're going to keep that up and bring you any updates if there are any questions or a verdict in that case. When we come back, though, we are going to turn to Idaho. For a Chad Daybell update, Chanley Painter will be with us to give us all the latest. Stay tuned.
I started hearing these stories about murder and stuff.
I'm about to be the biggest drug dealer that you can become.
Oh my God, are they starting a war with me or what?
I'm not gonna lie, it felt good to be a gangster.